The buyer got cold feet and does not want to proceed with the transaction. What happens now? I'll explain next on Tom's Take. You're definitely going to want to watch this one. If you've been selling real estate for any period of time, you know that cold feet is a real thing. Unfortunately, for a lot of buyers and sellers, they don't go through transactions that often. People are moving on average every 11 years, so they don't really know what happens when the buyer gets cold feet and doesn't want to move ahead now that you're under contract and haven't gone to settlement. So I want to explain a couple things and a couple ways this could play out so you know exactly what your rights are in the real estate transaction. And this is obviously specific to Pennsylvania agreement of sale. That's what I'm going to be talking about here. If you're watching out of state, call a local agent who understands the contract. So there's a couple ways where if the buyer gets cold feet, they're going to be able to get their deposit money back. And it depends on if contingencies have been elected in one case and another if it's in a homeowners or a condo association. So if they're in the inspection period, right? So you have that 10 or 15 day window. 10 is the default. 15 is what a lot of agents go to. You have that window of time where you can do your inspections and decide one of three things. The buyer can accept the property in the conditions stated in the report. The buyer can terminate the agreement if they're unsatisfied in any way, or they can negotiate for repairs or for a credit. So let's say, again, it's not an issue of inspections. Rather, the buyer just got cold feet. If they're still in that 10 or 15 day window or whatever's allotted for in the inspection contingencies, and the buyer changes their mind, they can terminate because they're unsatisfied. That's an option for the buyer. They will get their deposit money back. Obviously, we know that in order to release deposit, you need a two-party sign-off or a court order in Pennsylvania. Without going too much into the details there, let's assume both parties are going to sign off. And again, this is the buyer's right. They have that right if that contingency is elected, and there's really nothing that a seller can do about it. So that's one option. The second option, if they got cold feet and they're not through all the contingencies, is if you're in a homeowners association or a condo association. In the agreement of sale, this is required by law. This can't be changed. This can't be struck. There is a 5-day period to review all the rules, regulations, the budgets, the declaration for the association. And again, if the buyer's unsatisfied in any way, they have the ability to terminate the agreement. So if you're in one of those two time frames, the buyer can get out. Or if you're before the association documents get delivered, or you're in that inspection period and you maybe even haven't scheduled the inspection yet, you can use one of those two contingencies to move on, get your deposit money back, and not have any liabilities between parties, meaning the buyer and the seller. Now, the third thing that can happen if a buyer gets cold feet is they don't want to move ahead under no circumstances. They're not buying the house. And what's at risk? And at this point, you're assuming contingencies have been met. So the mortgage commitment's delivered. The inspection's been negotiated. Any document review for an HOA or a condo association has been done. So what are the ramifications? And I'm going to call everyone's attention to line 722 of the agreement of sale. In line 722, it says that the seller is limited to retaining sums paid by the buyer as liquidated damages, including deposit monies. So only what's been paid is what's at risk. And this is if you're a seller, you should be looking for at least a 5% deposit. A lot of agents try to get by with less. I'm really strict on this. We're strict on this at our team because that makes sure the buyer has some skin in the game. And a 5% deposit is pretty standard in a lot of ways. So that's one thing you really want to be focused on is the deposit money if you're the seller to safeguard against cold feet. And let's say the buyer's okay losing their deposit. They're willing to let the money go because they just don't want to buy this property. It's not going to happen. That is the only thing that can be retained by the seller is the deposit money. So those are the things that can play out and the different scenarios when a buyer gets cold feet. They can either use the inspection or the document review period to terminate the agreement and get their deposit money back, or ultimately they have to forfeit their deposit. And again, this isn't just as simple as saying, hey, we're keeping the deposit. There has to be a two-party sign-off on deposit release by the buyer and the seller, or then it would go to mediation and then ultimately go to court. So if you find yourself in this situation, really important to get legal advice here, not just real estate agent advice, legal advice. So I highly recommend that to anyone that's going down this road. And as a seller, I want you to know what your rights are and what they aren't. If they terminate based on inspections or the document review period, there's nothing you can do about it. And the best thing is to go find another buyer. Any questions? You need anything? You want to talk about this more? You know where to reach me. Otherwise, we'll be back next week. You're definitely going to want to watch this one.